Good morning or good afternoon, everyone. Thanks for joining in. My name is Lluc Cerda. I'm a senior associate at the Calgary office of Samfiru Tumarkin. We're here today to discuss the employment law Q&A. We're here to answer any and all questions you have about employment law. We're happy to do that for you. I'm here for the next half hour, so any questions you have, just put them in the chat, and I'll get through as many of them as I can today. While we wait to have some questions come in, I just want to tell you I had another trucker call me today asking me if he was entitled to severance. And the reason he was asking is that he'd been classified as a contractor for several years with his employer and was under the impression that contractors aren't entitled to severance. So that is not true. You can still be entitled to severance even if you're a contractor. Furthermore, a lot of people that are on paper classified as contractors might actually be employees in the eyes of the law. So if you're terminated and you've been working as an independent contractor, it's important that you contact a lawyer here at the firm at Samfiru Tumarkin so that we can tell you whether you're entitled to severance. So feel free to reach out anytime, or you can also visit our website, employmentlawyer.ca. We have a lot of information there about your rights under employment laws, whether you're a contractor, an employee, or what the issue might be. So feel free to shoot your questions in the chat, and I'll be happy to answer them as they come in, so that we can get everyone answered here. Feel free, don't be shy, and we'll get through as many questions as possible. All right, so I have a first question come in here from Stop Trudeau. How long can you be placed on unpaid leave by an employer for not getting vaccinated? So the question is this. The important question is, how long do you want to stay on leave? All right. So the fact is from day one of your leave, you can treat that as a constructive dismissal and go after your severance. The challenge with that, though, is that it presumes that you're willing to walk away from your job. You say, my job is over here. You've terminated me by placing me on leave, and I require you to pay me my severance. So the first choice you have to make is, are you willing to walk away from the job that you have? If you are, then it's important you contact us and we can tell you about what your severance entitlements might be. You can actually easily calculate those on your own on our website, which is pocketemploymentlawyer.ca. Pocketemploymentlawyer.ca. We have a good calculator on there that allows you to calculate what kind of severance you might be entitled to. Now that will only be the case, though, if it's your employer that's mandating the vaccine. If it's the government that's mandating the vaccine, there isn't much that can be done. So, for instance, if you work for an airline and you've been mandated to get vaccinated by the federal government, not much that can be done about that. But if it's your employer who on their own decided to put in a vaccine mandate and place you on unpaid leave, then it's important you contact us and we can tell you what kind of severance entitlements you're likely entitled to. We have another question come in here from JC2004X asking, aside from vaccinations, what other issues have been coming up consistently lately? Well, I can tell you from my perspective here in Alberta, another issue that some people might not be aware of, what happened at the very start of COVID is a lot of people got laid off. Now, so let's say in March of 2020, April of 2020, they've got laid off and they still haven't been called back to work. Well, in the eyes of the law, those people have been terminated and those people are entitled to severance. So even though the employer hasn't written to you to call you back from work, or if they haven't written to you to say that you're terminated, you have been terminated in the eyes of the law and you're owed a severance package. The challenge is that you have 2 years to go after that severance package. So we got March 2022 right around the corner. It's important that you get in touch with us so that we can tell you what your severance entitlements are. If you wait too long, you won't be able to go after them. So it's very important you get in touch with us. You can do that by visiting our website, employmentlawyer.ca. That's employmentlawyer.ca. We have another question here from Randolph asking, how do you know if you are a contractor or an employee if your employer is telling you that you are a contractor? So that's a great question, and a lot of people have that question. So it gets pretty granular once you get, looking at the law. But generally, the question that a court or the law is asking themselves is, if you're a contractor, you should be running your own business rather than working for somebody else's business. So I always give the example: you come in, you own a home, you want someone to come in and renovate your bathroom. All right. So that person that comes in, they have their own truck, they have their own tools, they work on their own schedule, they fit you in when they can. You pay them a flat rate that was agreed upon, no matter how long it takes. That's the rate that you pay. Whereas an employee, doesn't, for instance, own their truck. An employee goes to work when they're told to go to work. They do what their employer tells them to do, the way their employer tells them to do it. So that's an employee. It's the level of control that the person who's getting their bathroom renovated has over the contractor is minimal. Plus, the contractor goes from that house to another house, has 50 clients in a month. An employee only has one client, which is not their client, it's their employer, one person that they work for. So they're economically dependent on that person. So imagine, if we use our example of the trucker, this trucker has been driving for the same company for 10 years, using the company's trucks, wearing the company's uniforms and all of that. Basically, this trucker goes to wherever the company tells them to go. That's not a contractor, that's an employee. All right. That's someone that goes into work every day for the same company. The company has decided, well, I don't want to make payroll deductions, so I'm going to have this person invoice me, and I don't want to pay this person vacation pay, so I'm going to have this person be a contractor, or overtime pay, or statutory holiday pay, or in the end, severance. But whatever is written in the contract is not necessarily binding. So you need to have that reviewed by an employment lawyer here at the firm, so we can tell you whether you're actually a real contractor or whether you're actually an employee, in which case you're owed severance, you're owed vacation pay, you're owed overtime pay, you could be eligible for EI. So a lot of these things really fall into place. You have additional protections as an employee rather than a contractor. So it's important that you know in what case you're in. We have another question here from the Dreamer. Can you explain overtime averaging agreements and what they mean for employees? All right. So as you all know, overtime starts at 44 hours a week. All right. You work the first 44 hours, you're paid your regular salary, and then afterwards you're paid overtime pay at 1.5%. So what certain laws allow you, certain provinces allow you to do, or allow the employer and the employee to do, is come to an agreement. Whereas basically, if you work 44 hours in 1 week, or let's say 50 hours in 1 week, but only 25 hours in the next week, the employer can average those 2 weeks together, come up with about 37.5 hours per week. And since that's below the overtime threshold, then you're not owed overtime. All right. Without that agreement, you would have been paid 6 hours of overtime in the first week, but not any overtime in the second week because you only work 25 hours. So that's the purpose of overtime averaging agreements. I got a call here, Rusty Trucks from Windsor. I remember you, Rusty. Just saying hi. You take care as well, Rusty Trucks. Thanks for reaching out. I'm glad that you're watching the show. I hope we can answer your questions. We have another question from VS 2015M. Can you deduct any amount from the employee's final pay in Ontario or BC if they owe the company money? Example, so for property or an allowance that was conditional. So the reality is that no, that you are not allowed to deduct just anything you want from a final pay stub or any paycheck, really. And we see it often here at the firm. People get terminated. They're owed, say, under the Employment Standards Act, they're owed 4 weeks of pay. But the employer is saying, well, you know what? You broke this tool last week. That tool costs $500. That's coming off your severance pay. That's illegal. That's illegal in both BC and Ontario. And I'm here in Alberta. I can tell you it's illegal in Alberta. If your employer is doing that, if your employer has a contract that says that they're allowed to do that, it's very important you reach out to us. We can tell you if that's legal or not. Most often, those cases, that's not legal. Absolutely not. So if you have any questions about the way your pay is being treated, whether there's some illegal deductions that are being made, it's important you reach out. Contact us at employmentlawyers.ca. We have a question from Sarah on Facebook. My company is closing, and each of us have received a letter with the date in which we are done. If I get another job before I'm done, will I still get my severance? So it depends which province you're calling us from, or you're reaching out from us from. Depending in Ontario, there's on top of what's called notice of termination, which is what people usually call severance pay, there's an additional payment for certain employers called severance pay under the Employment Standards Act. Now, it's confusing, it gets complicated. Essentially, what it is if your company is big enough and if you've been there long enough, you're owed an extra week per year of service if you get terminated, over and above any severance that would be owed to you under any termination pay that would be owed to you. That's only applicable in Ontario. So you have to be in Ontario for that to work. So it depends when you quit. So for instance, if your employer, you've been there 8 years, your employer gives you 8 weeks of notice that your job was going to end, and you quit during that 8 weeks, then yes, you are entitled to the severance. If you're only owed 8 weeks under the Employment Standards Act, but the employer gives you 6 months of severance, and you quit after month 2, then you also forfeit that the Employment Standards severance pay. Complicated stuff. It's complicated, I get that, but you have to get into the granular of it to understand it. We're happy to walk you through it though, so feel free to reach out to us. We can tell you if you've been provided with a fair severance and what happens to you if you find new work. So feel free to reach out at employmentlawyers.ca. Jody Belanger asks, I would like to stay anonymous, but my question is, can the vaccine policy be challenged if you can prove you have ascertained antibodies from COVID infection? Depends what you mean by challenged, all right? So basically, your employer has no obligation to continue to employ you if you're not vaccinated, all right? The only obligation they have is to pay you severance. But to go after severance, you have to first make the decision, am I willing to walk away from this job? If you realize that you are willing to walk away from this job, then yes, you can challenge the policy. You can say, well, listen, I don't accept this policy. I won't continue to work for you because you don't want to employ me. Therefore, you owe me severance. And the fact that I have antibodies, the fact that I'm willing to wear a mask or do testing, should weigh in the decision on whether you have the right to terminate me or not. And in our view, the courts are going to say that there is no right to terminate people for not complying with a vaccine mandate that was introduced at the last hour. If you've been employed for several years, you never had to get vaccinated for the flu or anything like that, then why is this different? And so although you can't challenge it and say, employer, look, I have antibodies, you have to continue to employ me, you can say, look, employer, if you don't want to employ me, you owe me severance. That's as simple as that. So let's go. All right, we have another question from Facebook here from John. Can a healthcare worker that is not in direct contact with patients and works in maintenance be forced to be terminated without severance? The healthcare has long-term care also. And are they entitled to employment insurance? That really does depend on which province you're in. So in long-term care homes in Ontario, everyone is required to be vaccinated by the government. So you would have to be vaccinated as well. Here in Alberta, there is AHS has a mandate as well, requiring all of its long-term care homes for everyone to be vaccinated. The question kind of boils down to, is AHS just funding that long-term care home, or is AHS instead the owner of the care home and everyone's an employee of AHS? If you're an employee of AHS, you can refuse to be vaccinated as well and go after your severance. Again, I got to repeat, you have to first make the decision. I'm willing to walk away from this job. Nothing happens until you realize that you're willing to walk away from the job, because if you're happy to stay on leave, then you're not owed any severance. It's only when you refuse to stay on leave that you're owed severance, or if you're terminated. Alexander asks, I've been employed as a courier driver for 8 years. After 4 years, I was injured on the job, and my injury got progressively worse because of overtime. Can my employer force me to do overtime? So the fact is, if you're unable to do overtime because of your injury, then the first thing is to go see a doctor and have a doctor say that, all right, to get a doctor's note. So a lot of people have injuries, it could be a simple ache or pain, or it could be something quite serious. But the employer is not a medical professional. So the employer can't decide whether your injury is serious enough that you require accommodation. Only a doctor can do that. So the first thing is to go see your doctor. If your doctor agrees that you shouldn't be doing overtime, then your doctor will give you a medical note that you give to your employer. Now the employer has a duty to accommodate you, all right? And if they fail in that duty, then you could go after severance and human rights damages for their failure to accommodate you. The first step is to go see your doctor, have your doctor write a note saying that you can't do overtime. JC 2004X asks, if a company closes an office or moves locations but offers you a position at the new location, could that be constructive dismissal? You might not want an extra travel time, or you may not want to move. That can definitely be a constructive dismissal. Of course, you can imagine the very, very serious examples. Your company, you're based in Toronto, your company asks you to move to, New Brunswick, for instance. Well, there you have an issue, right? Because you're selling your home, you're moving your family, your spouse might have to leave their job. So that's a very serious constructive dismissal. Absolutely. On the other end of the spectrum, they move, two houses down, 2 buildings down the street, and it's an extra 2-minute drive. That would not be a constructive dismissal. All right. I can tell you if you're being required to drive an extra 30 minutes or more, then that's probably going to be something that amounts to constructive dismissal. So it's going to be very important to figure out whether you've always worked in that same location your entire life or your entire career, or if you've been moving around already and there's been a pattern of you changing work locations. But if you've been at the same place all this time, you're being asked to travel, an extra, 30 minutes or more, then it's important you contact us and we can tell you whether that's enough for you to claim constructive dismissal and go after your severance. Absolutely. Linda Sherman asks, put on an unpaid leave of absence in October 4th. My employer says I'm still employed when I ask for vacation pay. So theoretically, if you're happy to stay on leave of absence, then you remain employed. That's the truth, all right? So leave of absence is not a termination, but it can be a constructive termination. But for it to be a constructive termination, you have to say so. You have to say, I don't accept being placed on leave of absence. If you're happy to stay on leave of absence and your employer is happy to keep you there, then the employment relationship continues. Either when you decide that you want to, follow the employer's mandate, or the employer changes their mandate and calls you back to work, there's still a job for you to go back to. Got a question from Tanya on Facebook. I'm a unionized nurse who's been placed on indefinite leave because of the vaccine mandate. Can an employment lawyer help me, or should I go to the route of civic court and personally sue the people in the hospital's leadership? So Tanya, unfortunately, I think neither of those options are available to you. When you're unionized, your collective agreement states that your representative is the union, all right? So if you've been placed on an unpaid leave of absence, really the only option that you have is to file a grievance, all right? And the grievance, you'll be represented by your union. Your union might decide to hire a union lawyer to represent you at the grievance. That's up to them. But unfortunately, you don't have the right to hire an employment lawyer on your own. We're not allowed to represent you in court, and you're not allowed to go to court. The first thing the employer will do if you go to court is ask the judge to throw out your lawsuit because you should have started a grievance. So it's important that you go see your union rep and tell them you want to file a grievance. The Dreamer asks, are dependent contractors still owed severance as regular employees? So we've been talking about the difference between independent contractors and employees. And independent contractors, if you remember in the example I gave you, is that contractor comes in to renovate your bathroom and does 50 other bathrooms in the month or the year or whatever it is. There are people that are not employees in the eyes of the law. They're contractors. but they contract really for just one entity. So imagine you renovate bathrooms, but you do it in a hotel. So you work in this huge hotel. It's got 200 rooms, and for the next 5 years, you're renovating all the bathrooms in the hotel. Halfway through, they terminate you. So what you can say is that you're not a true independent contractor. You are a contractor, yes, but you're a dependent contractor, which means that even though you're a contractor, you got all or substantially all of your employment income from that one source. In those cases, you're still owed severance, exactly the same way as if you're an employee. So you're not a contractor, so you're not an employee, so you wouldn't get vacation pay, overtime pay, statutory holiday pay, but you would still be owed severance. So if you don't know whether you're a contractor or an employee, but you do know that you get all or substantially all of your income from one employer, then even if you are a contractor, you're still owed severance. Absolutely. Don Glass asks, my mom went on the caregiver's benefit as my dad is ill and needs taken care of. They don't want PSWs entering their condo because of COVID. The caregiver benefit ran out. If my mom decides not to return to work because of my dad and his health, is she entitled to severance from the employer, who says she still has a job when she decides to return? She has been on leave for approximately 15 months. So if you yourself take a leave, be it a disability leave or a caregiver leave to take care of your loved ones, and your employer is happy to let you stay on leave, then no, you are not entitled to severance, because there is a job waiting there for you if you want to go back. So what you could ask your employer is whether they can accommodate your return. So I don't know, in this particular case of Dawn's, whether her mom might be able to work 2 days a week or 3 days a week, in which case the employer would have a duty to accommodate her up to the point of undue hardship. But if Dawn's mother is completely unable to return to work and hasn't been terminated as a result, then there's no severance owed. If the employer terminates her down the line for whatever reason, it's important, Dawn, that your mom contacts us to see if there's anything that we can do. But because there has not been any termination by the employer, and there's a job that your mom can return to, she's not owed severance at this time. Nan asks, if an employee uses often the restroom, leaving her duties unattended, can I ask for a doctor's note to accommodate her with her frequent bathroom breaks? So, I mean, I personally think that people should be able to use the bathroom if they need to go. I have no idea how frequent we're talking about here, and what kind of duties are being left unattended. If the employee does get a doctor's note, then there would be a requirement that they be accommodated. Essentially, kind of hard to say how frequent and all of that is, but basically people are entitled to use the bathroom. Mark D'Occasion asks, my wife's employer is arguing about the workplace accommodation needs. She has a disability. What type of information do we legally need to provide for a proper accommodation? That's a great question. And unfortunately, it's one that people don't often ask themselves. So it can seem intrusive that the employer is asking you for a lot of medical information to show that you require an accommodation. That is because the employer has a duty to accommodate you, so they need to know a little bit about what your disability is. They're not allowed to know the diagnosis. They're only allowed to know what your restrictions are. All right. So oftentimes the employer, once you give them a doctor's note, might send you a form. It's often called a functional abilities form. The form is a chart you send to your doctor, and it'll ask the doctor things like, how long can this person stand? How long can this person walk? How long can this person sit? Is there any stressors in the job that make it impossible for this person to work? What's this person's concentration like, and all of that? That's because the employer needs that information to then look at your job description and see if they can accommodate you in your job description. So for instance, if you work as a machine operator where you're on your feet for 8 hours a day, but you have a restriction that says you need to sit every 30 minutes to take some weight off your feet, then the employer needs to know that so that they can decide whether they can accommodate you in your position as a machine operator, or if there's another job where you're not required to stand so much that you could be accommodated in. So all these things need to be considered. So it is important that you provide that information. If you refuse to provide any medical information from your doctor, so that your employer can accommodate you, you might, be disentitled to severance or human rights damages down the line. So it's very important that you collaborate with your employer in coming up with an accommodation plan for yourself. JC 2004X asks, if you do not agree with your union's decision, I believe you can file with the labor board, although I don't know if you can appeal the decision or not. So JC, that's absolutely true. So if you feel that your union is not representing you adequately, you can go to the labor board and file an application, a duty of fair representation application. What you're asking the labor board to determine is whether the union has been representing you fairly. If the labor board finds that they haven't, then they'll order the union to rectify the issue. These are not easy to win, I got to tell you. It's not just anything that'll make it that the union is not representing you, but that is the one option you have if the union is not representing you. Randolph asks, is it better to have a written employment contract? Should I ask my employer to provide one if I don't have one? My opinion is that it's actually, if your employer has not provided you with an employment contract, then that is fine. Okay, that's absolutely fine. I wouldn't chase after my employer for an employment contract. The reality is that even when you don't have a written employment contract, you have an unwritten employment agreement. And the terms of that agreement are taken from the law. All right, so the law is written, and the law says that you have certain entitlements, right? And the contract, which is drafted by the employer, serves to limit what the law says that you're entitled to. So the law often says a lot of things about entitlements, and in contract, you can decide something different, all right? And that's legal, all right? But if you don't have the contract, then the law applies, and the law is generally a lot more beneficial than what the contract provides. You got to remember who's drafting this contract and whose benefit is it for, and it's oftentimes for the employers. So if you do have a written an employment contract, go ahead and have it reviewed by us. You can reach us here at employmentlawyer.ca. We can review that contract. If you and your employer are happy to work on the premise that you don't need a written employment contract, I think that's generally more beneficial for employees. I would not chase an employer to get a written employment contract. Alexander asks, besides my doctor's note, should I put anything in writing about the progression of my injury and submit it to my employer? I mean, you can if you want to, Alexander. Honestly, the employer is only required to listen to your doctor's opinion, all right? Not your opinion about your medical restrictions, okay? So you should get your doctor, if your illness has progressed, you should get your doctor to write that. Have your doctor say how that has affected your restrictions. Have your doctor say what you can and cannot do in the workplace anymore. It's important to go through your doctor. So my name is Lluc Cerda. I'm the Senior Associate of the Calgary, Alberta Office of Samfiru Tumarkin. So I've been answering your questions today. I know we haven't been able to get to everyone. We have a show every day this week, so feel free to join us again tomorrow and thereafter, and we'll get to some of the questions that that I haven't been able to get to today. So thanks for tuning in. And remember, you can reach us anytime at employmentlawyers.ca to discover your rights, get to know what your employment rights are. If you just want to know what your severance entitlements might be because you're curious or because you're afraid you might lose your job now or in the future, you can visit our severance pay calculator. And you can find that at pocketemploymentlawyer.ca. It's anonymous. You don't have to tell us your name. You don't have to tell us your employer's name. We don't save that information. So if you just want to use the calculator and figure out what your entitlements might be, go ahead and jump on there and see what you might be entitled to. Thank you all for joining today. It was my pleasure to answer your questions, and I hope to see you again